Hello everyone and welcome back to the channel. In today's video we'll be exploring one of the most dynamic and fast developing areas of English tort law, namely the tort of misuse of private information, commonly abbreviated as MOPI, M-O-P-I. Although it feels like privacy law has always been part of our legal landscape, the truth is that the tort is a very new arrival. For decades, English law insisted that no general tort of privacy even existed. Yet, through a combination of breach of confidence cases, the influence of the Human Rights Act 1998, and a series of celebrity-driven battles in the early 2000s, a fully fledged privacy tort eventually emerged. Today, we'll walk through the origins of misuse of private information, the modern two-stage test, the key cases, how courts balance privacy against freedom of expression, and the remedies available. Let's begin with the foundations. Privacy doesn't mean the same thing to everyone, and historically, English law protected privacy only indirectly through other torts like trespass, defamation, malicious falsehood, harassment, or property law. This is in marked contrast to countries like, for instance, France, where privacy is given strong protection both in criminal and civil law, as well as Germany, where privacy enjoys constitutional protection. The Prince and Princess of Wales, for instance, have successfully sued the media in France for intrusive paparazzi photographs taken of them on their honeymoon, as well as more recently in 2025 of their family holiday. Princess Caroline of Monaco has, in the von Hanover cases, which we'll return to later in this lecture, also vindicated her privacy rights, this time at the European Court of Human Rights. But what has all this to do with English law? For a start, the European Convention of Human Rights and its interpretation in the European Court of Human Rights have had and continue to have a major influence on the development of the English tort of misuse of private information. But first, let's look at how this very young tort came into existence. Just to repeat, historically, English law protected privacy only indirectly through other torts like trespass, defamation, malicious falsehood, harassment, or property law. The case that made a gap in the law glaringly obvious was that of Kay versus Robertson in 1991, where journalists photographed this actor, Gordon Kay, in hospital after a serious head injury. He was semi-conscious, he clearly couldn't consent, but let's quickly run through the torts that ostensibly already protected privacy at that stage and see whether he could claim based on any of them. Was there trespass to the person? No, because there was no assault, battery, or false imprisonment. Was there a nuisance? No, because this tort protects interest in land. Was there defamation? No, as the actor's reputation wasn't harmed. And the same goes for malicious falsehood. There was no breach of confidence, as there was no pre-existing commercial interest between the parties. Clearly, none of the torts that were said to protect privacy actually protected Gordon Kay. And neither, for that matter, with the torts of harassment, which was created years afterwards, or our current data protection legislation. So getting back to Gordon Kay, the Court of Appeal therefore noted, regrettably, that there was no tort of invasion of privacy. Lord Justice Glidewell put it like this: "It is well known that in English law there is no right to privacy at that stage." So this case marked the limit of what the old law could achieve. But soon after came the UK Human Rights Act, which incorporated into UK law from the European Convention of Human Rights the latter's Article 8, which is the right to respect for private and family life, and Article 10, which protects the right to freedom of expression. These rights would become central to the transformation of breach of confidence into misuse of private information. Before the tort of misuse of private information existed, privacy claimants relied mainly on the traditional equitable tort of breach of confidence, whose core test came from or was illustrated in the case of Coco versus A.N. Clark in 1969. In this case, Mr. Coco had developed a prototype of a motor scooter engine. He entered into discussions with A.N. Clark Engineers Ltd, a company he hoped would help manufacture or commercialize his design. To allow the negotiations to proceed, Coco provided technical information, drawings, and details of his prototype engine to the company. He claimed that this information was confidential and supplied for the limited purpose of the negotiations. However, the negotiations broke down, and later Mr. Coco then alleged that A.N. Clark had improperly used the confidential information to manufacture their own scooters without his permission. He therefore brought an action for breach of confidence. Judge McGarry set out the classic three-part test for breach of confidence, the test which became the foundation later on for our modern tort of misuse of private information. So McGarry J. held that to succeed, a claimant must first show the information must have the necessary quality of confidence. It must not be trivial, for example, or already public. Secondly, the information must have been imparted in circumstances importing an obligation of confidence. And thirdly, there must be unauthorized use of the information which then acts to the claimant's detriment. In this particular case, the court held that Coco had not provided sufficient evidence that the company had actually used his confidential information in developing their own products. So the claim failed on the facts, but the principles established here became hugely influential. Originally, breach of confidence was about commercial secrets, trade information, employer confidentiality, and government leaks. But the courts gradually expanded it. In the case of Argyle versus Argyle, for example, it protected private marital information. This case concerned the very public divorce of the Duke and Duchess of Argyle, which you see in the picture photo to the right there. You'll find a link in the description below to an article and also the BBC drama based on the affair called A Very British Scandal, and there you see the actors in that drama. Also, in the case of Attorney General versus the Guardian newspaper number 2, which is commonly called the Spycatcher case because it's based on the book with the same name, the House of Lords confirmed that an obligation of confidence could arise even without a pre-existing relationship, so long as the recipient knew or should have known that the information was confidential. These developments, in other words, the broadening of the tort of breach of confidence, laid the groundwork for our modern misuse of private information analysis. Despite the expansion of the equitable tort of breach of confidence, English judges repeatedly insisted that there was no general tort of privacy. In Wainwright versus the Home Office in 2004, for instance, involving a humiliating strip search, the House of Lords stressed that only specific torts existed: trespass, harassment, breach of confidence, but not one on privacy as such. Yet the courts were feeling increasing pressure, especially in cases involving the press, the tabloid press, and this came to a head in the case of Douglas versus Hello in 2001. This case involved unauthorized photographs of the actors Michael Douglas and Catherine Zeta-Jones and their wedding. They had sold exclusive rights to OK magazine, but a freelance photographer from Hello infiltrated the event and sold pictures to Hello. The court held that the photos were confidential because the couple had controlled authorized access and made the confidentiality clear. This signified the moment that breach of confidence began migrating and splitting towards a full privacy tort. Shortly after Douglas, a pivotal point came with the judgment in Campbell versus Mirror Group newspapers in 2004. The model Naomi Campbell had publicly and repeatedly denied that she used drugs. The Mirror newspapers, however, published articles and photographs of her attending Narcotics Anonymous. That then gave the lie to her claim that she didn't use drugs. In the subsequent suit that she brought, the House of Lords held that it was in the public interest to correct her misleading statements about drug use. However, revealing details of her treatment plus the photographs they held was a misuse of private information. And crucially, Lord Nichols said that the essence of the modern action is best understood as in those words precisely, misuse of private information. And this then brought us to a new tort. The two-stage test for this tort was also born. Stage 1 is, we ask, did the claimant have a reasonable expectation of privacy? You'll see that I abbreviate that as REP. Now, this depends on all of the circumstances. The claimant's characteristics, the nature of the information, the context in which it was obtained or published, the method of obtaining it, and its potential impact. Stage 2 is a weighing up exercise. Is the claimant's Article 8 right more important than the defendant's Article 10 right? So this requires a very careful balancing exercise between privacy and freedom of expression. The more the material contributes, for example, to a debate of general public interest, the stronger Article 10 becomes. However, if the information is purely intrusive gossip, Article 8 will usually prevail. What's important for you to know is that we start with step 1, and only if you can establish a reasonable expectation of privacy do we go on to stage 2. If you cannot establish a reasonable expectation of privacy, we don't even have to go to stage 2. Let's explore first then stage 1 in detail using several key cases. Starting with Campbell again, the House of Lords emphasized the effect that disclosure might have, especially given Campbell's vulnerability during addiction recovery. In Terry versus Persons Unknown in 2010, the footballer John Terry sought to stop publication about an affair that he had had. The court refused an injunction, partly because the information wasn't especially sensitive, and partly due to John Terry's own very robust personality, which suggested that there would be limited emotional harm to him. With regards to sexual activity, the courts draw a very strong line. For example, in Mosley versus News Group in 2008, Max Mosley, who was the boss of Formula One, he had a claim and in misuse of private information, which succeeded because the courts held that consensual sexual activity between consenting adults is inherently private. In other cases, such as Ryan Giggs versus News Group newspapers, the courts acknowledged the same principle. The court gives more weight to free speech in public as opposed to private activities, but photographs in public spaces might even so attract privacy protection. It all depends on the context. The case of Sir Elton John versus the Associated Newspapers in 2006 confirmed that there is generally no expectation for privacy for photos showing people doing ordinary things in public. Justice Eadie refused Elton John's injunction because the images that were taken in this case were taken as he was walking from his car, and they conveyed only trivial information. And this was comparable to an example that Baroness Hale made in the Campbell case of, for example, just popping out for a pint of milk. However, the European Court of Human Rights has taken a more protective approach. In von Hanover versus Germany, the first von Hanover case in 2004, it held that Princess Caroline of Monaco's Article 8 rights were breached when paparazzi persistently photographed her going about everyday activities such as going to the supermarket, because such images did not contribute to any debate of a general interest. A later case, the second von Hanover case in 2012, however, showed that publication could be justified where a photograph is genuinely linked to an issue of public interest. In this case, a picture taken during a skiing holiday accompanied reporting about Princess Caroline's father, the monarch of Monaco, Prince Rainier, and the ill health that he was suffering from. Although Elton John's case was distinguished on the basis that he was not subjected to a harassment as was Princess Caroline, the European Court of Human Rights reasoning focuses less on harassment and more on public interest. If considered today, I would say that the UK courts might be expected to move closer to the European Court of Human Rights stance that even mundane images may be protected unless they contribute meaningfully to public debate. With regards to children, children are given enhanced protection. In Murray versus the Express newspapers in 2008, featuring the author J.K. Rowling's infant son, it was established that even everyday scenes may give rise to privacy rights for children, particularly where parents try to keep them out of the spotlight. Now, turning back to this first step then, can you have a reasonable expectation of privacy information that is already in the public domain? The answer to this is yes. Not all publicity necessarily destroys privacy. In the case of the Prince of Wales, as he was then, Prince Charles, now King Charles, well, in Prince of Wales versus Associated Newspapers in 2006, it concerned private circulation of diary entries made by Prince Charles to 70 people. The court held that this did not make those diary entries public. In PJS versus News Group newspapers in 2016, similarly, the court held that even widespread foreign publication of pictures catching the claimant in very compromising situation, even though they were very widely published outside of England, the court held that such publication did not defeat privacy, where domestic injunctions protected children from a possible media storm. So just to repeat, with regards to photographs, in Campbell it was held that photographs contain more information than textual description. So the old saying that a photograph paints a picture of 1,000 words, that's very, very true. And we generally have a higher reasonable expectation of privacy with regards to photographs, even if these photographs were taken in public. In the case of Peck, for example, these were photographs that were taken by CCTV on the streets of the United Kingdom, and these photographs were used by the police in order to prevent a suicide on the part of the claimant. The question was then whether these photographs that were taken in public could be published, and the court held no. There was an expectation of privacy on the part of the claimant, even of photographs that were taken in public, because of the nature of the photographs. Now, once a reasonable expectation of privacy is established, the courts then weigh the privacy against press freedom. That's step 2. So a further case dealing with children's privacy, cited here on the slides, pointed out a very important principle, namely that when the courts go up to that second stage, when they weigh up the Article 8 right to privacy to the Article 10 right to freedom of expression, neither of these two rights start off with an advantage. They start off being regarded as equal. And it will depend on the facts of each case which right will be regarded as more important than the other in those specific circumstances. But remember, the first step is to prove to the court that there is a reasonable expectation of privacy in the first place. If the claimant cannot establish this, then no misuse of private information will be present. It is only once a reasonable expectation is established that we go on to step 2, the balancing exercise. In the Campbell case, the Part 2 balancing exercise resulted in the court holding that, firstly, publishing the fact of drug use was allowed as it was in the public interest. But secondly, publishing details of the therapy session with the photographs were not allowed. Therefore, it is clear that the court place a heavy weight on whether publication is in the public interest. But they also allow publication of matters that form part of a public debate. For instance, in Rio Ferdinand versus Mirror Group newspapers in 2011, publication contributed to a debate about the England captain's role model status. Next up, the courts also allow publication if it is about correcting false impressions. So the courts sometimes permit publication to correct misleading images crafted by celebrities. In Campbell, this was a false claim about drug use. In the case of Beckham versus News Group newspapers, it was about allegations about marital image making. That case was settled out of court. In the case, going back to the case of Rio Ferdinand, this world-famous footballer cultivated an image as a reformed family man. But this was put to the lie when a photo of him with a woman that was not his wife in a hotel room was published. The court allowed the publication as the photo itself was not intimate and it was clearly taken with both parties' consent by another person in the room. But importantly, the court held that the publication corrected a false impression. However, remember that this does not mean that minor inconsistencies would justify intrusion. They don't. With regards to criminal investigations, this area has seen major developments. In Bloomberg LP versus ZXC in 2022, the Supreme Court held that a person under criminal investigation but not yet charged generally has a reasonable expectation of privacy. This protects individuals from the no smoke without fire assumption that can destroy reputations before any evidence is even tested. In Sir Cliff Richard versus the BBC, the famous singer Sir Cliff Richard succeeded in his claim because the BBC named him during a police investigation. He was never subsequently arrested or charged, and the coverage was very sensationalist and intrusive. They even sent a helicopter to go and film his property. Naming him was not required to inform the public debate. However, once someone is actually charged with a crime, open court reporting usually overrides privacy. With regards to publication of biographies and autobiographies, in other words, where you are telling your own story, privacy cases often involve the conflicting rights between private individuals, not just between individuals and the media. For example, in McKennett versus Ash, the defendant, Miss Ash, published a book about her experiences of going on tour with Miss Lorena McKennett, a very famous Canadian singer. And this book covered, amongst other things, Ms. McKennett's personal and sexual relationships, her personal feelings, including how she had reacted to the death of her fiancé some years earlier, her health and diet, her emotional vulnerability, and details of a dispute between McKennett and Ash. Miss Ash claimed that she was telling her own story as well, but the court clarified that, yes, you may tell your story, but not someone else's private information without their consent. And this sentiment reappears in the case of Bull versus de Sport, where intimate revelations about a lottery winner's private life were held by the courts to be impermissible, not permitted. Finally, privacy remedies include, firstly, injunctions. Injunctions are often the most valuable remedy, and an injunction can be issued urgently, even late at night. Section 12 of the Human Rights Act requires courts to consider freedom of expression before granting an injunction. Interim injunctions require the claimant to show that they are likely to succeed at trial. Secondly, damages. Damages are generally lower than the ones obtained in defamation, but awards can still be significant. For example, Naomi Campbell received £3,500, and in FXG versus Gaunt, 2023, involving surreptitious filming and online uploading of intimate images, the court awarded very substantial damages for psychological harm, treatment costs, and the ongoing distress of images potentially remaining online forever. This case was the first in the UK where a personal injury award was given for revenge porn. To summarize, misuse of private information is a modern judge-made tort which originated from the breach of confidence equitable tort, and it was shaped heavily by human rights principles. It uses a two-stage test. First, is there a reasonable expectation of privacy? If so, secondly, we go on to balancing Articles 8 and 10, freedom of expression versus privacy. The case law in this area is highly fact-specific, especially around photographs, sexual activity, children, and criminal investigations. Remedies include injunctions and damages, with injunctions often being the key goal. Misuse of private information reflects the ongoing tension between privacy and press freedom, an area which is likely to continue evolving and developing as technology, media practices, and public expectations shift. Thank you for watching. If you found this helpful, please like and subscribe, and feel free to leave questions in the comments. See you in the next one.